Welcome back to the deep dive. Today we're digging into something really fundamental in criminal law. What happens when someone does something clearly criminal, think reckless driving, assault, but they argue it wasn't, them, that it was because of some unexpected reaction to a prescription drug. It throws a wrench into the whole idea of mens rea, the guilty mind. We've got this wild case: a guy crashes, lies to the cops, even breaks an officer's nose and claims he remembers nothing because of Valium his doctor prescribed. So our mission today is to really unpack the difference between voluntary and involuntary intoxication. It's a high bar for a defense, apparently.
Absolutely.
Yeah.
And to figure this out, we need a clear path. First, we'll look at voluntary intoxication, or 6, and see why it's pretty limited as a defense. Then we'll dive deep into involuntary intoxication, too. There are actually 4 types the law recognizes. And finally, we'll apply the court's really strict test, the one linking it to temporary insanity to this specific case, City of Minneapolis v. Altimus.
Okay, let's do it. Starting point, voluntary intoxication. When does that actually work as a defense?
Well, the general rule is quite narrow. 6 is only a defense if the crime requires a specific intent or purpose, think like premeditated murder or burglary. And the defense has to show the intoxication was so severe it actually prevented the defendant from forming that specific intent.
Hold on, let me just clarify that for everyone listening. So reckless driving, that's general intent, right? You just intend the act of driving.
Exactly. You intend the act itself.
But for something like, say, attempted murder, the prosecution has to prove you specifically intended for the person to die. That's the difference.
That's precisely the line, yes. And because the main charges in our case here, Altimus, things like careless driving, hit and run, don't need specific intent. 6 is basically off the table. Liability just requires intentionally or negligently doing the act itself. Doesn't matter if you intended the harm.
Right. So 6 is a dead end here. That means it all comes down to involuntary intoxication, too. What's the core idea separating that from 6?
The fundamental principle is about volitional fault, or rather the lack of it. The idea is you shouldn't be held criminally responsible if you didn't consciously choose to become intoxicated. The common law recognized this, but, and this is key, only if the involuntary intoxication made the person temporarily insane.
Okay, 2 is the path, but involuntary sounds like it could cover a few scenarios. You said there are 4 types.
That's right. The law generally recognizes 4 ways intoxication might be considered involuntary. First, coerced intoxication, basically, being forced under duress. Very hard to prove, though. Second, pathological intoxication. This is where someone has a grossly excessive reaction to a substance, something totally unexpected given the amount, because of a susceptibility they didn't know they had. Third, intoxication by innocent mistake. Maybe someone tricks you into taking something you think it's aspirin, but it's, PCP. And fourth, the one relevant to Altimus, unexpected intoxication from a medically prescribed drug.
Okay, let's use that 4th category and our structured approach to tackle City of Minneapolis v. Altimus. First up, what are the key facts the court focused on?
Right, so the crucial facts are Robert Altimus gets Valium prescribed for back pain and the flu, takes it as directed. Then he drives a radically illegal left turn, hits something, leaves the scene, damages property. When confronted by police, he seems confused, gives a fake name. Later, there's an altercation, and he actually breaks an officer's nose before they subdue him. His claim: he took the Valium, remembers absolutely nothing, believes the drug made him lose control. And critically, his doctor testified. Said, yes, drowsiness is normal, but things like hyperexcitability, confusion, those are possible, though rare side effects. The doctor conceded Altimus might have been suffering those unexpected effects.
Got it. And the central legal issue for the Minnesota Supreme Court?
The core issue was whether the trial court messed up prejudicially by refusing to let the jury even consider the defense of involuntary intoxication, especially since Altimus did present evidence suggesting his actions stemmed from this unexpected drug reaction.
So what rule did the court lay down for this specific type, the prescribed drug scenario? Can you state the rule and break down its elements for us?
Okay, the court set out a 2-part test. They held the defense is available only if the drug was taken based on medical advice, A and D. First, the absence of knowledge element. The defendant must not have known or had reason to know that the drug was likely to have the intoxicating effect it did. And second, the legal insanity element. The intoxication must have resulted in the defendant becoming temporarily insane under the state's specific definition, which was the Omnoten test.
Okay, thank you. Let's get into the court's elemental analysis, step by step. How did they handle that first element, the absence of knowledge? I mean, Valium, people know it makes you drowsy, right? Why wasn't that enough knowledge?
That's a really important point. The court zeroed in on the unexpected nature of the intoxication. Yes, drowsiness might be expected, but Altimus described, and his doctor acknowledged the possibility of, much more severe effects: hyperexcitability, confusion, amnesia. These went way beyond simple drowsiness. So the court found this evidence that the reaction was both severe and unexpected was enough to raise the sub-issue. It meant the defense could argue to the jury that Altimus lacked the necessary knowledge of that specific kind of intoxicating effect.
Okay, so it's not just knowing any side effect, but knowing about the specific kind of severe behavior-altering effect that actually happened. Makes sense. Now the big one. The second element, legal insanity. The court tied this to the Imnatin standard. How did they say this had to be proven?
Right, the court was explicit. The involuntary intoxication isn't enough on its own. It has to cause temporary insanity. And they defined insanity using the state statute, which was the Imnatin test. Did the defendant, due to a defect of reason from the intoxication, not know the nature of their act or not know that it was wrong? Now, applying that, Altimus testified he was basically unconscious of his actions, completely unable to control himself. Pretty extreme claim. The court decided that this testimony, this claim of total lack of awareness and control, was just enough evidence to raise the sub-issue of temporary insanity for the jury. They felt the jury should have been allowed to hear the instruction and weigh that evidence. Especially since, interestingly, the jury had found him not guilty on the assault charge, which needed specific intent. That suggested they might have believed his story about the Valium's effect to some extent.
So putting it all together, what was the final conclusion of the court?
The Minnesota Supreme Court concluded that Altimus had presented enough evidence to potentially meet both elements of the involuntary intoxication defense, lack of knowledge of the specific effect, and temporary insanity under McKnighton. Therefore, the trial court's refusal to give the jury instruction was a reversible error. They reversed and remanded the case for a new trial where the jury could properly consider the involuntary intoxication defense.
Okay, let's use an example to make sure we're clear on the different types of involuntary intoxication. You mentioned innocent mistake. How does that differ from the Altimus situation? Let's look at People v. Penman. What happened there?
Penman is a striking case. There, the defendant killed his wife. He'd taken some tablets he genuinely thought were just breath mints or something similar, but someone else had deceived him. The tablets were actually cocaine. The court said that was involuntary intoxication. Why? Because while he chose to swallow the pills, he was completely mistaken about their character. He had no idea they were an intoxicating substance due to someone else's deception. That's the key difference from Altimus.
Got it. So Penman is about deception regarding the substance itself, while Altimus is about an unexpected reaction to a known prescribed substance. Clear distinction. Now back to Altimus, there was disagreement, right? Justice Rogos's concurrence argued against using the Imnatin test. Why did he think it was a poor fit for drug-induced states?
Yeah, this is a really interesting point. Imnatin, fundamentally, is about cognition, knowing right from wrong, understanding the nature of your act. It's very intellectual. But Justice Rogowska argued, essentially, that some drugs might not destroy your knowledge that something is wrong, but might instead create an overwhelming, uncontrollable urge, an irresistible impulse. You might intellectually know hitting someone is wrong, but be chemically unable to stop yourself. McKnighton doesn't really capture that loss of volitional control very well. So he proposed using the Model Penal Code MPC standard instead. The MPC test is broader. It asks if the person, due to the involuntary intoxication, lacked substantial capacity either to appreciate the wrongfulness of their conduct or to conform their conduct to the law. That second part, conform their conduct, directly addresses the possibility of an irresistible impulse, which the stricter Imnatin test often misses. It recognizes a potential disconnect between knowing and doing. Okay, so to wrap this all up into something practical, maybe for issue spotting if you ever encounter a situation like this, here's a kind of diagnostic checklist based on what we've discussed. 1. What's the crime? Does it require specific intent, or is it general intent or negligence? That dictates whether 6 is even relevant. 2. Was the intoxication voluntary, meaning did they know or should they have known about the intoxicating effect? Or was it involuntary, coerced, pathological, innocent mistake, or unexpected prescription reaction? 3. If it was voluntary, you only proceed if it's a specific intent crime. Did the 6 actually negate that specific intent? It's only a partial defense usually. 4. If it looks like 2, involuntary, then you analyze it as a potential complete defense. Which of the 4 types fits? 5. If it's the prescribed drug type, like Altimus, apply that 2-part test rigorously. Step A. Did the defendant know or have reason to know about the specific intoxicating effect they experienced? If yes, it probably bumps back to being treated as voluntary. Step B. If no, did that unexpected intoxication cause temporary legal insanity?
Under Minneapolis, that means they didn't know the nature or wrongfulness of the act. Or, under the MPC view, they couldn't conform their conduct. Both parts must be met for the defense to succeed under the Altimus rule.
Right. We went from, a fender bender and a scuffle to the absolute core of criminal responsibility. It seems the law is willing to excuse seemingly criminal acts, but that door only opens if the drug effect was genuinely unforeseen and it fundamentally broke the person's ability to reason or understand right from wrong, at least under the Minneapolis standard. The stakes are incredibly high: acquittal versus conviction, all potentially turning on whether your doctor's prescription unintentionally provided a defense by making you, legally speaking, temporarily insane.
And it leaves us with that lingering question, the one Justice Rogoshevsk raised. In our modern world, with ever more complex drugs affecting the brain in diverse ways, is a test from the 1840s, focused solely on cognitive knowledge, still the right tool? Does Minneapolis adequately address situations where someone loses control, developed an irresistible impulse due to medication, even if they still intellectually grasp right from wrong? It's that tension between adapting the law to modern science and sticking to established statutory definitions, something for you to definitely mull over.